Mr. President, our liberties we prize, our rights we will maintain. It's on the state banner that stands behind you and something that we remind ourselves of frequently in the legislative process. And yet there's something about this resolution that runs contrary to that, and it's specifically within the language of it. We do not recognize a right. We expressly are stating no, a right does not exist. And I go back to the senator from Dallas's opening remarks when he talked about this being necessary because of unelected judges. And Senator Chapman, I agree and disagree with judges frequently. But I don't agree that we can call them unelected judges. Decorum's a big deal in this chamber. It's a big deal in the legislative process, and it's certainly a big deal in our courts. And we have a process for electing judges. See, judges in Iowa are appointed by the governor and then face a retention election. And the judges in 2018 who reached a decision in the case of Planned Parenthood versus Reynolds had been elected by the people of Iowa who chose for them to sit on the court. In that decision, Justice Cady outlined some important things about our judicial branch. And I want to read some excerpts from this decision because I think they are relevant to us understanding just how seriously our courts take these issues. They do not sit over there like Caesar and say yes or no to their own political will. As Senator Mathis pointed out, they take fundamental rights and evaluate whether our legislature has violated fundamental rights. So I'm going to quote from this case. We begin by reflecting on the role of the judiciary within our venerable system of government. The Iowa Constitution, like its federal counterpart, establishes three separate yet equal branches of government. Our Constitution tasks the legislature with making laws, the executive with enforcing the laws, and the judiciary with construing and applying the laws to cases brought before the courts. The framers believed those who undervalue the role of the judiciary lose sight of a greater blessing when the legislature denies to the humblest individual the protection which the judiciary may throw a shield around. Our courts are there to make sure that the motto on that banner does not become meaningless, does not get eroded. They are there to place that shield around our rights. And when we talk about the right to abortion, we frequently talk about rights like privacy, rights like equal protection and treatment under law, due process, substantive due process to ensure the outcome of proceedings is fair and constitutional to our citizens. They're not light questions, and these rights didn't spring up in 1973 under Roe versus Wade. They are time-honored American traditions that we protect these rights. They're why we set up the form of government we did with the limitations it has. To protect not 60,000 representatives and senators or individual citizens, but one person at a time. One person's rights. That's what our court set out to establish and interpret. And I know it may be fashionable on the other side of the aisle to denigrate our courts and dismiss the judicial branch. But it is important. It is a co-equal branch, and it does have a place in our system. And yes, our courts did decide this case on the merits and evaluating it with the constitutionally sacred process of judicial review. And in doing so, they analyzed equal protection under law. They analyzed substantive due process to make sure our legal system results in a conclusion that accounts for rights and protections our citizens should be afforded. And in doing so, they established the Act's mandatory delay indiscriminately subjects all women to an unjustified delay in care, regardless of the patient's decisional certainty, income, distance from clinic, and status as a domestic violence or rape victim. The Act takes no care to target patients who are uncertain when they present for their procedures, but instead imposes blanket hardships on all women. They evaluated the law, they looked at equal protection, and they made a very reasonable conclusion, not a political conclusion. The Iowa Constitution guarantees all men and women are by nature free and equal. It further promises all laws of a general nature should have a uniform operation. The General Assembly shall not grant to any citizen or class of citizens privileges or immunities which, upon the same terms, shall not equally belong to all citizens. Our Constitution's guarantee of equal protection of the law is the very foundation principle of our government. Liberty and equality are intertwined. Equal protection of the law now prevents governments from denying to women, simply because they are women, full citizenship stature, equal opportunity to aspire, achieve, participate in, and contribute to society based on their individual talents and capabilities. Profoundly linked to the liberty interest in reproductive autonomy is the right of women to be equal participants in society. We're here talking about a resolution designed to undermine the courts, largely because you disagree with that decision. A decision focused on protecting equality, a decision focused on protecting due process under the law, a decision based on privacy considerations. Our state has consistently led on these things. When the state infringes upon a fundamental right, as the court said, the guarantee of equal protection of the law requires the state to demonstrate an action is narrowly tailored to serve a compelling government interest. That's the question the court is resolving. And our state has acknowledged in our own Constitution, in setting a stronger equal protection standard than the federal government, that we have a duty to lead the nation on these constitutional issues. And so as we sit here with a banner in front of us telling us to preserve and protect our rights, it should chill us that our action today in regards to the Constitution is to consider whether or not we are going to express in that document certain rights are denied. I hope we thoughtfully consider the magnitude of what is being done in this resolution, rather than simply considering our position on an issue. Because this does a lot more than simply set a legal standard. This is going to have a lasting impact on our Constitution and how it interprets rights that are not mentioned in the resolution, that are affected by these decisions. And if you're a conservative, protecting privacy, protecting equality under law, protecting substantive due process should be paramount to your beliefs. And for that reason, I ask for a no vote.